The attendees can't hear you.
I thought they could hear you now.
No, you're gonna listen.
You there?
For those of you who are in already, I just wanted to make sure that you can hear me. If you can respond in the questions section, if you can just give me an affirmative that you can hear me, that would be great, and we'll get started a few minutes after noon. Okay, everyone, we're going to go ahead and get started. My name is Michael Foster. I'm an attorney here at Kirschenbaum Kirschenbaum, and today I'm going to be speaking about subcontractor 1099 versus employee in the scope of your business. I specialize in employment law, and a lot of what I do is in terms of contracts. So this is sort of an area that I've is sort of my expertise, and then we'll discuss the consequences of misclassification. So I've made a sort of roadmap for today. First, we're going to touch on what is an independent contractor, what is a 1099, how does it differ from an employee, what factors determine how to classify those who work for my company. So, for instance, what sort of factors play into the test of how determining whether I can bring on 1099s. And if I'm using the term independent contractor and 1099, those are interchangeable. 1099 is just the form that you fill out with the IRS for independent contractors, whereas a W-2 is interchangeable with an employee for the purposes of today's webinar. And then, do payments or contracts matter for 1099s versus employees? The pros and cons, and then we're going to touch on a new California Assembly Bill 5, which just recently was signed into law by the governor, which sort of places further restrictions on those who can be classified as 1099s. For anyone who's listening in California, and even for those of you around the country, this seems to sort of be the trend. It's almost a knee-jerk response to what's considered those who work in what's called gig economies, which is essentially Uber, Lyft, the delivery services. So those who work for, those of you who know, Postmates, apps like that. And so those who are sort of for hire on those, and this is almost a direct response in response to those. And then we'll touch on how it can possibly affect you as in the alarm business, and those of you who are engaged in the trade, and how it might affect your business moving forward. So what is an independent contractor? For the independent contractor, the company withholds income. For the employee, the company will withhold income tax, Social Security, Medicare from wages paid. For the independent contractor, the company does not withhold these taxes. A business may pay an independent contractor and an employee for the same or similar work, but there are important legal differences between the two, which for the most part depend on the tax implications for both parties involved. A lot of times 1099s are paid slightly more per hour or a slightly high percentage more, depending on the area, because the business does not have the additional payroll costs. Employment and labor laws also generally do not apply to independent contractors, generally only employees. So what factors go into the determination of how or who can be considered an independent contractor? Well, the most important is the nature and degree of control by the principal. This relates to how much the controlling entity or the principal, how they're determining, when they work, where they work, sort of the hours that they're required to put in. All of these are factors, and the more control you have over an individual who's working for you, the more likely they're to be considered an employee versus a independent contractor. Another factor is the extent to which the services rendered are an integral part of the principal's business, the permanency of the relationship, and the amount of alleged contractor's investment in facilities and equipment. The following factors have also been considered significant in determining independent contractor classifications: the alleged contractor's opportunities for profit and loss, the amount of initiative, judgment, or foresight in open market competition with others required for success of the claimed independent contractor. But as we'll see, this factor is sort of changing a little bit later on, especially with regards to that California bill. And the degree of independent business organization and operation. Generally, it boils down to supervision and freedom. If you're determining how and when the individual works, then likely they'll be deemed an employee as opposed to a true independent contractor. So payment, how can you pay an independent contractor versus how do you pay an employee? Generally, independent contractors are paid some flat fee for services rendered or a percentage based upon sales. This fee is agreed upon by the business owners and contractor after they both come to terms on the specifics for the project, but prior to work kicking off. A lot of you use probably independent contractors for your sales agreements, for alarm sales. As you'll see later on, this may be an issue, especially with the new legislation moving forward. But probably my guess is they're working on some sort of percentage. So that's how you would pay them. Even though not an employee, you still want to have a contract for independent contractors, so nothing is left up for interpretation. It should be clear and concise. The contract does not, on its own, imply an employment relationship. It depends on the terms in the contract. You don't want to get caught up in any miscommunication about either money or scope of work. Contract workers are fully responsible for their own expenses, including all taxes. This means you have no obligation under a true 1099 as an employer for federal, or as a controlling entity for federal, state, or local taxes, Social Security or Medicare benefits, workers' compensation insurance, or employment taxes. All tax filings are the responsibility of the independent contractor. Your only responsibility is to pay the contractor's fees per contract or as agreed upon, and then supply a Form 1099, which is where obviously the 1099 distinction comes from, each January detailing payments made. A W-2 employee, again, the W-2 comes from the form, the IRS form. A W-2 employee is the common classification for an employee who works to an employer's specific needs and schedule, receives a regular salary, and receives certain employee rights and benefits that are afforded by federal and state labor law, such as minimum wage, paid sick days, and health insurance. Generally, most of the workforce is considered W-2s. It's more of a small minority that's independent contractors. Most people who work are W-2s. Again, they're given a salary, sick days, vacation days, in the workforce. So control. This is sort of again the buzzword that I mentioned before, and that we will sort of harp on and be one of the main tenets of this webinar is the control. So the major difference courts assess to determine whether a worker is an employee or independent contractor, again, is the level of control the worker has over his or her schedule and the means by which they complete their work for employers. Any contract you have, we highly recommend it's reviewed by an attorney. Just because it says 1099 in the contract does not necessarily mean that it's a true independent contractor. And again, you're always putting yourself at risk of misclassification and having to pay back damages a lot more if it's misclassified than if you would have initially had them as W-2 from the first place. The concept of control is the biggest factor that goes into whether a worker is truly an independent contractor. If you're telling them when to work, how to work, treating them like an employee, they can certainly file a claim against you. If successful, the worker could receive back pay, damages, and possibly punitive damages as well as for you having to pay court costs and attorney's fees. A long story short, as I mentioned, you could be on the hook for a lot more than what it would have initially cost to put the worker on the payroll. That can't be, specified or harped on enough. Is that if you want to have the ability to dictate the worker's schedule, how they're working, you're probably better off just putting them on the payroll. I carefully chose these pictures because it not only shows control, but shows me going through your arrangements. If I had a nickel for every time a client, provided a 1099 or independent contractor agreement that wasn't a true independent contractor agreement, I'd be able to retire. The second one is my face after a client tells me, well, it says independent contractor in the contract, so I'm safe, right? Again, not the case. Don't know how many times, if you can take one thing away, take that and the ability and the control aspect away from this webinar. Withholding and deductions from contractor pay. An independent contractor is a self-employed worker that does not draw a salary from an employer, is not entitled to minimum wage, and has far fewer rights or benefits under the law. In most cases, no federal or state income tax is withheld from the pay of an independent contractor, and the contractor is responsible for paying his or her own income taxes and self-employment taxes. If you are bringing in an independent contractor on a contractual relationship, you will want to make sure that you have language in your agreement that the individual is a 1099 and is responsible for withholding all taxes. This is important language in the agreement because it further specifies and lays out the relationship from the get-go. This way, you will make sure that the person you are bringing on is aware that they should withhold their own taxes and there is no confusion. Again, a lot of these issues come from confusion, so the more upfront you are and about everything, the better off is how you'll be. Withholding under backup, withholding regulations. Contract 1099 employees are not on your payroll, and we're providing services for you. Full-time employees are on your payroll, and you're much more responsible for how they do their job, plus supervising their work. Employers need a W-9 form for the independent contractor before work begins. In some cases, the taxpayer ID on that form may be incorrect or missing. In those cases, you may have to withhold federal income tax from that person's payments. This is called backup withholding. Labor laws. So both federal and state law entitle employees to certain benefits that are not afforded to independent contractors, such as minimum wage. Federal minimum wage is $7.25 per hour. Again, depending on the state you're in, it may be higher. New York, California, those states are higher for the most part than the federal minimum wage. They're also not afforded unemployment benefits, paid sick days, and health insurance. The U.S. Department of Labor, and more specifically the Fair Labor Standards Act, govern misclassification at the federal level. And at the state level, each state will have a Department of Labor which may place further restrictions than the federal level, but may not remove any of the restrictions. It helps to think of the federal laws as sort of the floor or the basement of the minimum standard required, and then states may add on to that if they find further restrictions are necessary. Some of them, as you'll see, specifically the California bill places further restrictions on who can be classified as a 1099 versus an employee. Bringing in an independent contractor reduces an employer's payroll obligations drastically, as employers are required to withhold taxes from W-2 employees' paychecks. Independent contractors are required to report and pay taxes using a 1099 form, as I mentioned. However, there is always the risk of misclassification, which could run tens of thousands in the long run after damages are calculated. Additionally, I know we received a question about alarm licenses. There's many reasons an alarm license may be revoked, including fraudulent, anything that's considered fraud, making false statements, incompetency. If misclassification knowingly continues, I think is an important distinction there. If it knowingly continues, if you've been, gotten into trouble for this before and had to make payback, and you continually, knowingly make this distinction erroneously, I think you're putting yourself and your alarm license in liability to be revoked in the long run. So it's just something to be aware of. It's not just limited to the only with the Department of Labor is where you would find the issue with the back pay. There are also other entities that govern the alarm industry specifically, which you could find yourself an issue with if things continue at a fraudulent or a misclassification at that level. What are the pros and cons of 1099s? Obviously, you have reduced payroll obligations. You don't have to provide benefits, and it provides flexibility for smaller businesses starting out as their reduced obligations. You don't have to pay your share of the employee's Social Security and Medicare taxes, state unemployment compensation insurance, or workers' comp as well. What are the cons of a 1099? Well, there's a bunch. Significantly less control over workers, including schedule and provision of services. There's a lot of uncertainty, less loyalty and reliability with workers, and you risk significant exposure if not classified correctly. For 1099s, you can have a manual with suggested methods, but you risk liability if control goes beyond that. So, for instance, if you have a manual that provides, some methods that you generally employ as a company, that would be, considered okay. But if you go further and saying, provide limitations, then you risk that misclassification, and liability would be much greater than if paying for the person on having the person on the payroll. So again, it must be done right. So I know a lot of you are from in the New York area, as we are, so I wanted to touch briefly on just a few other restrictions under New York law, or a few other factors that go into the New York test for what is a 1099. Works at his or her own convenience, free to engage in other employment, receives fringe benefits on the employer's payroll, or worked on a fixed schedule. Obviously, these are similar to the factors we touched on before, but just provide a little bit more clarity, especially in terms of the free to engage in other employment or fringe benefits. So California's new Assembly Bill 5. So on September 18th, 2019, California Governor Newsom signed California Assembly Bill 5 into law, codifying and expanding the California Supreme Court's decision in the Dynamex case and the ABC test for determining if a worker may be classified as an independent contractor instead of an employee. So just so you have a little background, this is sort of the state legislature's response to these apps. So for instance, the ride-sharing apps like Uber, Lyft, I'll default to those because those seem to be almost what it was directly trying to address when moving forward. So to satisfy the ABC test and legally classify as a worker as an independent contractor, the company must prove that the worker is free from the company's control, 2, performs work outside the company's primary business, and 3, is regularly engaged in the trade the worker is hired for, independent of the work for the company. So beginning on January 1st, 2020, which is when this will go into effect, the ABC test will be the test used to determine whether a worker providing services in California is an employee for the purposes of the California wage orders, the labor code, and the unemployment insurance code. This means that workers claiming misclassification as independent contractors can and will use the ABC test to make claims that they are employees and are entitled to make claims such as failure to reimburse necessary business expenses, failure to provide accurate and complete wage statements, failure to pay unemployment insurance tax, and failure to provide workers' comp. However, Assembly Bill 5 does not extend the ABC test to any other claims under the code, only under the Department of Labor. So, for instance, how does it, how necessarily would this affect me? So, if your company's primary business is the sale and installation of alarms, you cannot bring on 1099 in sales. So, this second factor here, that performs work outside of the company's primary business, is really the meat and potatoes of this new bill. So, for instance, as I mentioned, if your company engages in the sale of alarms, and that's if you just do the sale of alarms, then you can bring a 1099 in to install the alarms, and vice versa. But if you do both, then you're putting yourself in significant risk under this new factor test. And as you can see, this was sort of, as I mentioned, a response to Uber. So, how would this sort of come into play is that, Uber is in the business of providing rides. So therefore, taxi service. So if a person is engaged in, providing services as a taxi driver, then that's sort of in the same company's primary business. So that's not outside, so therefore they would be considered an employee. And it all goes back to that. I believe that is sort of why this bill came about, is because of the rise in popularity of apps like that. So under the California law, here are some exemptions and those who are not exempt. Those who are exempt: doctors, lawyers, engineers. Just to give you an idea, again, not necessarily applicable, maybe to your sales and installation, but for other aspects, for contracts you may get into or hire. It's just for sort of to give you a broad idea of how the law applies and who it applies to. Again, the rideshare and delivery service workers are not exempt. Truck drivers, janitors, performers, campaign workers, etc. And again, these are not all of the exemptions. There are some more, but these are the ones I found were most applicable. So how did the Assembly Bill 5 affect my business? Companies must satisfy the ABC test or face increased risk of defending against additional claims from individual workers claiming to be employees, class action attorneys representing workers on a class or collective basis, and city and state authorities. Deciding what to do is only the first step. How to transition workers from independent contractors to employees is just as important to avoid triggering claims for past misclassification. So if you do currently have 1099s in California and you see that this may affect that, you'll want to speak with an attorney whose expertise is in this area about how we can transition these workers to employees to avoid, again, triggering any claims for past misclassification. But that's in reference to the bill. That's not as applicable since it's changing. But it would just be if you were always sort of misclassifying them, not as opposed to this new legislation. And then worker advocacy groups, as I mentioned, are gearing up in other states as well, including New York, Washington, Oregon, for similar legislative efforts. Again, the more, liberal or pro-worker states are likely to test out these, as they're considered more, in some instances, pro-worker, or to be considered that. So the more democratic states would necessarily start this legislation first, and then it would sort of make its way. So if you find yourself in a very democratic state, this may be, that's not California, you may find yourself facing similar legislation soon. Companies should monitor, and specifically we will, how narrowly California courts interpret this test, especially what the usual core of the hiring entity's business means. So this is essentially when is it considered, what percentage do you have to provide that service for it to be one of your primary services? So for instance, if you do only 25% sales, is that sales considered one of your primary forms of business? Or if you do, it has to be more than 50%. There's no real bright line rule yet. It's going to be interesting to see how that progresses and the arguments on each side. And where a business decides not to reclassify, revising the company's existing independent contractor agreements and policies to more clearly satisfy the ABC test is key. Deciding to replace independent contractors with third-party staffing agencies or labor contractors will require selection of agencies or contractors that comply with the law, uphold the obligations of their agreements, and indemnify their clients for violations of the law, since companies are often found jointly liable for wage and hour violations of their contractors and agencies who provide such workers to their businesses. Again, it's a lot to unpack, and I don't mean to rain like it's the end of the world, but this seems to be the trend in a lot of places, especially those where Uber, Lyft are popular, California, New York, and sort of all those regions. So in those areas, this seems to be the trend. So it's better to get out in front of it and then to have to address it later. But that's what I wanted to touch on today, and I hope that this webinar was very informative. My contact information is up here. If you want to take a look at our contracts, you can visit our website. Ken's information is on the website as well, and peruse around a bit. But if you have any questions regarding any of these matters, anything discussed today, please feel free to give me a call or shoot me an email, and I'll be happy to get back to you and go through any way of how I think we can help improve your contract and reduce your liability in the long run, which is always the important thing for small and large businesses as well. Have a good Thursday, everybody. Thank you for listening.